the two major issues concerning women around which large movements were built, or around which passions were generated on both sides, okay, in United States. But of course, the women's voting rights movement, the suffrage movement in the early part of the last century and previous century also, and the abortion, the issue concerning abortion. In India, these two issues have not really caught the imagination of the people in the way it had caught in USA for various reasons. As far as the voting rights are concerned, the Indian Constitution, right from the time it came into existence, granted full voting rights to adult women. So that was never an issue. As far as abortion is concerned, you must realize that till 1971, I'm sorry, till 2071. Sorry, I'm missing out on my centuries, but till 2071, abortion was a crime in India. It was a crime in the sense that the only law which dealt with abortion was the Indian Penal Code, which is a pan-India law brought in by the British in 1860. And it penalized what they called miscarriage, okay, or forcing miscarriage, etc., etc. And it continues to penalize it even today. So Indian Penal Code essentially penalized the what we call the miscarriage, or loosely defined as abortion. Okay? And it penalized both the doctor as well as the woman. So till 71, there was nothing else except a criminalized situation of abortion in India. 1971, you have for the first time the Medical Termination of Pregnancy Act. Now again, this is a pan-India act applicable across India. A Medical Termination of Pregnancy Act for the first time allowed certain kinds of abortions in India and termed them as legal. Now, even Indian Penal Code, which talked about miscarriage being a crime or abortion being a crime, permitted abortion in cases where the life of a woman was under threat. So if life of the woman was under threat and an abortion is carried out, then it was not a crime. But otherwise, in all cases, it was a crime. 1971 Medical Termination of Pregnancy Act said that it allowed abortion in certain cases. For instance, up to 12 weeks of pregnancy, it permitted abortion provided one doctor, one registered medical practitioner, would certify that the woman, either her life is under threat, or her health would be under threat if she carried on the pregnancy. In the sense, her health would include both physical as well as mental health. That if her mental health or physical health was under threat, then abortion can be carried out up to 12 weeks of pregnancy. Or if the third ground was that if the fetus is likely to be malformed, as they called it, or deformed, as they called it, suffering from major physical disabilities, and that was found out, then medical termination of medical termination of pregnancy was permitted. That 71 between 12 and 20 weeks, 12th and 20th weeks, the same thing, same clauses apply. But between 12 and 20 weeks of pregnancy, you needed to have two doctors certify that a woman is that the woman suffers from these conditions. In which case she could terminate a pregnancy. After 20 weeks, it was not really permitted unless the woman's life per se was in danger. So basically, abortion in certain circumstances become legalized till the 20th week of pregnancy under certain circumstances. But really speaking, it was well known across India that doctors give certificates that this woman is fit for abortion up to 20 years. in a very, very liberal way. There were no protests, etc., etc., against that. I mean, doctors were not worried whether the conditions stipulated was satisfied or not. They would give so abortions became a routine thing. One of the reasons, I mean, and there was never any strong opposition to abortion, like the free life movement, etc., which is, the life pro-life movement, which is in USA. There's nothing of the kind in India. Maybe for various reasons. One of the reasons, of course, was population. There are a lot of people thought that the population control is a very, very essential thing in India. So let us allow abortions. The other thing was a distinguishing feature between, under the Hindu law, the birth of a son is very important. So you had a lot of female infanticide, even when abortion was not there. Infanticide, because a daughter was born and not a son. So that was going on. So, so in that sense, for various reasons, you had abortion which was quite liberalized. In 2021, what happened was that the MTP Act, that is Medical Termination of Pregnancy Act, was amended, and it got amended by adding one more clause, because up to under the MTP Act, originally as it stood in 1971 until 2021, up to 20 weeks you could abort because of the grounds of women's health, etc., etc. What the 21 Act did was that it extended from 20 to 24 weeks. So now up to 24 weeks, you can abort a child. But while aborting a child up to 24 weeks, that is between 20 and 24, certain conditions were prescribed about the woman. In the sense that what the law said is that this will apply only in cases when a woman is subjected to rape, or if she's a minor, or if she's if she has been subjected to sexual assault, etc. Or these were the kind of conditions on which she was allowed medical termination of pregnancy. Before 20th week, the criteria on which you could allow termination of pregnancy did not depend on whether you were married or not married. It did not depend on whether you were raped or not raped. Those were not the criteria before 20 weeks. But between 20 and 24 weeks, the criteria, while they extended the permission to abort a child between 20 and 24 weeks, the criteria for of which kind of women, what kind of women can do this abortion changed. In the sense that, as I mentioned, that only if a woman is subjected to sexual assault, or if she is a minor, and one or two other conditions. This matter finally went to Supreme Court. So what the Supreme Court of India decided recently, the very famous judgment which has come out recently, was actually dealing with the criteria which was applied by the legislation between 20 and 24 weeks of pregnancy, during which abortions were allowed. The woman who went to court in this case was an unmarried woman. Now, if she had gone before 20 weeks, she would have been allowed abortion. It didn't depend on whether she was unmarried or married. But because of this stringent criteria that after 20, you have to be a married woman in order to get abortion between 20 and 24 weeks, she could not get abortion. She approached the court. And finally, the matter went to Supreme Court. Now, Supreme Court in the judgment says 3-4 things, which are very important. It says it does away with this criteria of married and unmarried woman. It says that this is not required. You can be married, you can be unmarried. If you're suffering from the same kind of problems as any other woman between 20 and 24 weeks, you should be allowed to terminate your pregnancy. That's one thing. Second thing it said is that this particular legislation, when it talks about allowing women, the entire legislation, now it's not only about 24 weeks, that when it talks about allowing women to abort, will not only apply to what is classically known as cis women, but will apply to any woman who can have pregnancy. So trans women, etc., were included in this for the first time. So that's the second. Third thing was that the Supreme Court said that, look, as far as the conditions, because even before 20 weeks, doctor had to come to a conclusion that carrying on with the pregnancy will harm the mental health or physical health of the woman. And the court said that the assessment of the woman as to whether it will harm her emotional well-being is something which is central to the whole thing. Okay? So you don't need some kind of a major psychiatric analysis or something like that to decide whether a woman would be harmed or not. Her own assessment, okay, whether her emotional well-being will be harmed or not, is something which the court said that's something which you bear in mind. Don't get into this whole question of how do you determine this social whether she's going to be emotionally whether her emotional life is going to be damaged if she carries on with the pregnancy. So that issue was also done away with. Not done away with, but it has been interpreted in a wide manner. Okay? The fourth issue which the court dealt with, okay, in this decision was the question of marital rape. See, marital rape has been dealt with only in a tangential way in this matter, because what used to happen is that the law, MTP Act, either before 21 or after 21, does not require the husband or guardians or spouse's consent for carrying out abortion. If you satisfy certain criteria which are given under the law, okay, then whether your husband consents or not, you have a right to carry out abortion. That's how the law is. Okay? What the court found is that in many times the doctors, okay, insist on getting the husband's consent, the partner's consent, etc., and without that they won't allow abortion. So the court said, sorry, this can't be done. This is not permitted under the law. If the woman's agency has to be recognized fully, if she wants to abort, she wants to abort. It doesn't depend on whether the husband agrees or not. That was the crux of the matter. In the context of that, this analysis, the court also came to the conclusion that, look, marital rape is very common. Okay? And we have to recognize the fact that marital rape is common. Okay? And therefore, to insist that a husband's consent is necessary, okay, would be a travesty of justice. Okay? Because a woman may conceive because there was a marital rape, or it may be because she had voluntary sex, but she may conceive because she had marital rape, and therefore this whole question of consent of the husband, okay, in order to allow a woman to abort, is something which is not permitted. The only thing it permitted is that if the girl who wants to get aborted is below 18 years, then the guardian's consent is required. That is what it said. That if it's below, Supreme Court has said that it's below 18 years, the guardian's permission is required. Now, coming back to the issue, which I was so this is a very prominent judgment of the Supreme Court, and I think it's gone a long way. A, in defining the agency of the woman. B, in saying that, look, I mean, all women who can bear pregnancy are covered, and not just what is conventionally known as cis women. It also recognized that unmarried women have as much right as married women. It also recognized marital rape to an extent. So if you look at it from these points of view, it's a it's a landmark judgment of the Supreme Court, and I'm sure it will go a long way in easing the whole issue. Coming to the other issue, which is about marital rape, now not in the context of abortion, but in a general context. Okay? While the rape has been recognized obviously as a crime, okay? And even if you see in India there is a procedure in if you want to divorce, okay, there is an option available to you that you go and get a judicial separation from a court. The court will say, okay, you are not being divorced today. Court may say, I mean, you may want a divorce right up front. That's a different matter. But if you want to work it, you want to try out. The court may say that, okay, we are judicially separating you for 1 year. And after 1 year, if you still feel that you don't want to get back together, you will be divorced. That kind of thing. Now here, what the court has said, the rape law, the criminal rape law, recognizes that during the judicial separation, if a man forces upon his wife, then it will amount to rape. Okay? But in a situation where there is no judicial separation, a husband and wife are living together, or it may be not even living together, and if a man forces himself on the woman, it will not amount to marriage. It will not amount to an offense of rape. That's what it may. You may say that this amounts to cruelty and a ground of divorce, etc., etc., but it will not amount to marital rape, and therefore it's not a crime. So this is the law which has been existing in India since a long time, and a large number of feminist groups have been opposing this, and various human rights groups have been opposing this. This particular law was challenged in the High Court, in the Delhi High Court, saying that marital rape should also be treated as a crime, and the definition of rape should include marital rape. That was the argument in the Supreme Court, in the Delhi High Court. Sorry, Delhi High Court rejected that case and said, sorry, we cannot include marital rape as within the definition of rape, and therefore it cannot be treated as a crime. It is for the legislature to decide. See, it took a position which normally the US Supreme Court takes, that it is for the legislature to decide whether it should be a crime or not. Remember one thing, that the Indian courts, Indian constitutional courts, the High Court and Supreme Courts have much broader power than the US Supreme Court. The powers are much broader, and they exercise it also in much more overt way than say the US Supreme Court would exercise. So the powers are much broader. Anyway, that case has now gone to Supreme Court because it has been challenged, saying in Supreme Court the challenge is pending that, look, as far as this is concerned, what do you call it? Marital rape is concerned, it should be criminalized. The case is pending in the Indian Supreme Court, and we don't know what will happen to it. But so that's the situation as far as marital rape is concerned. Just one additional thing which I did not mention about abortion and the judgment, which I wanted to just come back to for a minute, is that as far as you see, as I mentioned earlier, there is a huge under the Hindu law especially, getting a son is very important. Okay, because it seems that the pious obligations in respect of your ancestors can only be done by a male child and not by a female child, and for various other reasons like inheritance, etc., etc., the son becomes very important. So you have had a history of female infanticide, which goes centuries back. Okay? You have had a history where that has happened, from time to time. Once technology developed, you had all kinds of machines, which before the technology developed, you would know whether a child is male or female only after the child is born. So then it would lead to infanticide. Once this technology developed, you could detect whether the child is male or female, even when the child was a fetus. I mean, even at the stage of it being a fetus. So what started happening was that people started going to these maternity homes, etc., and trying to find out whether the child is a boy or a girl. And if the child is a boy, then then fine. If the child is a girl, many times they used to abort the child. In order to deal with this situation, the Indian government, the central government, came out with a law, or it was prevention of pre-diagnostic tests for finding out the sex of the child. You can do pre-diagnostic. You can do tests in order to find out whether the fetal is normal, not normal, etc. But you cannot. But the doctors were prohibited from telling people, telling the parents, or telling the woman or a husband or whatever, the sex of the child. You cannot tell before the child is born, and that's a crime. And the doctor who goes around telling this to the parents is committing a crime, and the parents would also be committing a crime by wanting to know this. So it's a complex question. So the abortion issue is I'm just trying to say it's a little more complex. I mean, it's straightforward in USA. You have pro-life and you have pro-choice. In India, on the other hand, you have it's a complex issue. Um, Even in terms of when do you allow abortion, when do you not allow abortion, etc., etc. And also in terms of the diagnosis of the sex of the child uh, within the womb. The Supreme Court order essentially deals with pregnancies from the period 20 to 24 weeks. Okay, before 20 weeks, the law remains the same, except that the Supreme Court expands this to trans people and various then also gives emphasis to the agency of the woman. I think one of the things by which there will be a liberalization of abortion is because of the Supreme Court's, even before 20 weeks, is because of the Supreme Court's observation that the agency of the woman is the most important thing. So she wants an abortion, and she feels that her emotional health will be traumatized because right now she doesn't want to bear a child for whatever reason. That has to be given a priority. So I think it will become important because a lot of doctors are scared. Because remember one thing, on the one hand, you have the Medical Termination of Pregnancy Act, which permits doctors to carry out abortions in certain situations. While on the other hand, simultaneously, you have the Indian Penal Code, which is a criminal law, which says that, look, if you carry out this in this way, then there will be a crime. So doctors do get a little apprehensive. But if so I think what is most important right now would be to, training of doctors, making them aware about this decision as to how this decision says various things. Because the Supreme Court itself recognizes that many times doctors don't realize that though the law does not require the spouse's consent, doctors insist on the consent of the spouse. Okay. Now, these things have been clarified in the judgment. So I think what the organizations in India can do, and they possibly will also start doing, or may have already started doing, is simplify the judgment. Judgment is like a research paper. Okay, you have to simplify the points into 4 or 5 major points, and explain and circulate it to doctors, circulate to maternity homes, etc. I think that's something which can be done.
Thank you.
See, the law right now says that, look, you cannot find out the sex of the child before the birth of the child. Okay? So it will, I mean, it's not that people don't find out. For instance, I know, like, for instance, in Gujarat, and the same thing happens across the country, but I'm just giving you the example of Gujarat, that while the doctors are not told, the doctors are told you can't disclose the sex of the child. If you go for a sonography test, okay, to a doctor, to a gynecologist, that doctor won't tell you whether you have a child or whether you have a male or a female child. Doctor will only tell you Jai Shri Ram or Jai Shri Sita. Okay, now that's how they will talk, So then you know exactly what the doctor means. Okay, so doctor is not formally violating the law, but you know what the doctor means. And then you decide, okay, I want to abort, I don't want to abort. So everybody is in the loop, that kind. But if you go legally, you are not supposed to know the sex of the child. So the decision to abort cannot be based on the footing of what the sex of the child. So that so if you go legally, then this is the thing. At the ground level, of course, there are many problems. That's all. See, what happens is that, as I mentioned, as far as this aspect is concerned, the Supreme Court doesn't change the law. The Supreme Court explains the law, okay, which according to the Supreme Court was already existing law. Okay? A woman, okay, can get abortion up to 24 years or 24 weeks now, if she feels that her emotional health is going to be damaged by carrying on with the child. Okay. Up till now, nobody knew how do you decide whether somebody's emotional health is going to be damaged, whether you believe the woman, you don't believe the woman, etc., etc. But now the Supreme Court has clarified that her saying that her emotional health will be damaged is a significant ground to be taken into account to decide whether the woman will whether abortion is required or not. Okay. Now, if a woman is, for instance, domestically abused, and she feels that she doesn't want to carry on with the child, okay, that by itself would be a ground by which she can go and say that I want an abortion. Okay? So in that sense, it has been liberalized. Right. As I was saying, abortion per se has never generated the kind of passions it has generated in USA. And that could be for various reasons. Okay. That one of the reasons could be that women were seen so much as part of the property of the husband. Okay. Under all religions, I mean, women is part of the property of the husband. So that is something which was always the case. Second thing is you had you see the stigma was against two things. Stigma was against, one is premarital sex. Okay, that you are not supposed to have premarital sex, extramarital sex. And second is you can't, and premarital sex was something which was in a sense avoided by child marriages. Okay, that if a woman gets married at 12 and 13-year-old, I mean, that I'm talking about, say, 100 years back, 150 years back, even now child marriages take place. Say a woman gets married 12 years at the age of 12 years, 13 years. Premarital sex is not something which is very likely to happen. This was the way they went up. Second thing is extramarital sex. Now, extramarital doesn't mean only while you are married have sex. It also means post-marriage, because virginity is given very, very grave importance under all systems of religion, Hindu religion also. Okay? And therefore you had, and it was much more important here because that's why you had a prohibition of widow remarriage. That a widow cannot get remarried. Okay, she's no more a virgin. Where is the question of getting her getting married? I mean, that was one of the issues. I mean, there were various other issues why widows were not allowed to get married. Property, Hindu undivided family, and divisions in that property, etc., was one of the issues. But one of the major issues was this: that she is no more a virgin. There is a question of her being allowed to get married. That can be. So there are various other. So there are various reasons why abortion was never really that big an issue in India. People used to get aborted. People even now get aborted. Only a real problem used to arise after 20 weeks, even now. Okay. And today also, if you go to court, because what the law says and what the Supreme Court says is that after 20 weeks, you have to set up a medical board. It's not just dependent on one doctor or two doctors. A medical board has to be set up. And that there should be one medical board per district in one government hospital, before whom the case of the woman will go, and they will examine whether she's and that has to meet every second day, every third day kind of thing. But many of the states have not set up these medical boards. So if you go to the High Court of Bombay, for instance, you will find every second day there is some case of a woman who comes to the court and says, I want to go to the medical board. There is no medical board set up. What can I do? And the court will then direct a medical board to be set up, and you ask the woman to go before that. But there are those kind of situations. I mean, those kind of problems do exist. Yeah. Thanks.
Thank you.
Generally speaking, even without this law, okay, even an illegitimate a child, a so-called illegitimate child, okay, has rights under the law, okay, including the right to get maintenance from the parents, especially if you know the parents. Okay, you have a right to, if you know the parents, then you have a right to get maintenance till you are 18 from the parents, etc., etc. Because the basic feature of any child-related legislation or any child-related judgment has to be best interest of the child. That is what they go by. That what is in the best interest of, that's across the world. So what is in the best interest of the child, and you determine on the basis of what is in the best interest of the child. So that way, this judgment will not make any impact on that. Impact on those laws. Those laws, like you had a case where a person went to court at the age of I think 40 or something, saying that a particular politician is my father, and make him do DNA tests, etc., etc., etc. He's not owning me up. He was not claiming any property or anything. He just wanted a recognition that he's the son of a particular person, okay? And the court granted it. So the rights of an illegitimate child are not very less than a right of illegitimate in a very broad sense. I'm using the word. Those rights are already recognized under the Indian law, okay? And this judgment will not make any impact on that. That's all. See, the only thing what the court says is that, look, consent of the husband is not required. And consent of the husband is not required. One of the reasons which the court gives is possibly because this conceiving of the child can also arise out of marital rape. And while one doesn't recognize marital rape today under the criminal law, okay, for the purposes of this law, we will recognize even marital rape. Okay, and therefore, so that is one of the reasons. That is one of the reasons why the court says that, look, I mean, see, what this particular bench was trying to do was give its the judge who gives this judgment, authored the judgment, Justice Chandrachud. Okay? He loves to explore areas which are not yet explored. Okay, so he might go into an exploratory line of analysis without it having any impact at the ground level. So he does that in a very. If you see, he was also the author of the decriminalization of homosexuality law in India. He was also author of that judgment, and he does that. So he goes into various areas. Marital rape still remains non-criminalized in India. Okay, so but for the purpose of this law, they say that we have to recognize that marital rape does take place. We have to recognize incest does take place at times. And therefore, we can't always ask for, we can't insist that the consent of the spouse is required in order to get abortion. That's the long and short of it. Okay. See, the problem is this, that ultimately the society drives the law doesn't drive the society. Okay? So you can make all the changes you want in the law, unless the society changes, the way of looking at it changes, it will have marginal impact. I don't say that it won't have impact. For women who actually want to get abortions, okay, after between 20 and 24, it will have an impact. But a lot of, I mean, even despite the husband's consent not being required, for instance, now, okay, even then, I mean, in 95% of the households in India, okay, I don't see a situation where a married woman, okay, despite the husband's and the in-laws' objections, will actually walk into a maternity home and say that, give me about my child. It's practically, it may not happen. Okay? But what happens with law is it opens up certain avenues for women who are or in any kind of area. It opens up avenues for people to use the law. The law is available. It's an instrument available. 90% of the people are not going to use it. But for those 10% or 5% who can use it, it becomes, and thereby it slowly expands. I mean, remember one thing, before 1955, under the Hindu law, divorce was banned. Okay, there is nothing like divorce under Hindu law. Hindu law did not recognize divorce. Okay, and 1955, first time you had divorce as recognized under the Hindu law, through the act. And at that time, people said that, but Hindus are so ingrained in not believing in divorce that nobody will use this law. But if you see over the years, millions of people are going and asking for divorce. So it takes time. It takes time to percolate, but it happens. Well, the only, you see, I have not looked at it from this point of view, very frankly, but but just thinking out aloud, I feel one of the ways in which you can do it is that after a particular when you're talking about, say, the emotional distress, because one of the conditions is emotional distress, etc. At that time, you discuss with both of them, okay, as to what each one of them feels. Okay, so while coming to see, if it's a physical danger to the wife carrying on the abortion, which is one of the criteria, then obviously whether the husband says yes or no doesn't really count, because it's a question of a physical health. When it comes to a question of emotional health, Okay, on the other hand, which is an alternate criteria for granting abortion, okay, you may say that, look, in order to determine the emotional health, whether it's going to be affected or not, let me have a discussion with both of them. So those kind of uh, avenues and roads can be provided. At the moment, they are not there, but they can be explored. I'm not very clear as to what can be done, but this is a possibility. My standard answer to this question has been that even murder has been misused. People are being jailed, okay, falsely accused of murder. Are you going to say, therefore, do away with murder as a crime? I mean, why does this issue come up only when the issues of women's rights, okay, and mainly it comes up either during women's rights or Dalit rights in India, okay, the SC/ST Atrocities Act or 498A or DV Act, etc., etc. So I think it comes up during that time. You see, sexual harassment, it comes up during the issue of sexual harassment in workplace, etc. And in all these issues, it comes up. I personally would say that yes, not all complaints are genuine. Nobody says that all complaints are, but don't throw the baby out with the bathwater. Okay? You can't say that because there are two complaints or five complaints which are false. Okay, therefore, okay, you and a law.